Good morning, good afternoon, and good evening to all. Thank you for your patience as we proceed in this webinar on specific exemptions and acceptable purposes under the Stockholm Convention. My name is Yvonne Ewang, and I'm here with my colleague Kay Ono. The idea is that we would present to you for about half an hour today, and then have an exchange with you afterwards, allowing an opportunity for you to ask questions and to exchange about specific exemptions and acceptable purposes. So without further ado, just to set out a little bit the structure of how we will proceed today. We will introduce the webinar and its objectives, then we'll provide a presentation and have about half an hour of discussions and questions before concluding. So we hope that there will be plenty of time for you to exchange between yourselves, as well as to speak to the Secretariat about any questions that may have arisen in your day-to-day experience when it comes to specific exemptions and acceptable purposes. So what are we trying to do? The idea is to enhance understanding of what exactly the requirements are to have an exemption available and to register for an exemption under the Convention. The Secretariat was also requested by decision SC 12-1, which was adopted in 2025, to provide, subject to the availability of resources, awareness-raising activities to improve parties' understanding of the procedures for registering specific exemptions and acceptable purposes and notifying other exemptions. So this is part of those efforts to raise awareness and to help share that information about these provisions of the Convention. We also hope at the end of the webinar that you would be familiar with the processes that relate to this and where you can find further information. A disclaimer before we go ahead, just to say that in all that we do, we'll set out what the Secretariat's practices are, but we are certainly guided by the parties, and none of what we will refer to should be considered as interpretation of the Convention. It is setting out what our practices are, and we always look to be guided by the Conference of the Parties and the parties themselves as we go forwards. So what does the Convention actually say, diving into the substance of our webinar today? The main provisions you will find in Article 4 of the Convention, which sets out that any state may, on becoming a party, by means of a notification in writing to the Secretariat, register for one or more types of specific exemptions in Annex A or B. Then there is a time limit set out in Article 4, stating that unless there's an earlier date indicated by the party itself, or if there's an extension granted, all of the registrations expire 5 years after the date of entry into force of the Convention with respect to that particular chemical. In terms of the process for extending the expiry date, that's set out in paragraph 7 of Article 4. We'll look into that in a little bit more detail further on in our webinar. But paragraph 7 sets out that the COP, so the Conference of the Parties, on request from a party concerned, may decide to extend the expiry date of a specific exemption for a period of up to 5 years. And in taking that decision, it takes into account the special circumstances of developing country parties and parties with economies in transition. There are some exemptions that have a distinctive time frame. So those are set out in the different parts of Annex A or B. When you look at Annex A or B in the Convention text publication, you'll see that initially there's the table with the list of the POPs, but then afterwards, for particular chemicals, there are specific parts that have provisions that relate to those chemicals. The examples being hexa and hepta BDE or tetra and penta BDE. The same applies for P4, for Declarin Plus, and for UV328 that have their own specific sections for those particular chemicals. To also highlight or draw to your attention that there are other exclusions that are set out in the convention. So articles 3.1 and 3.2 state that the provisions do not apply to quantities of chemicals used for laboratory scale research or as a reference standard. We also have the notes that come after the table in annexes A and B. And those set out, amongst other things, that unintentional trace contaminants in products and articles are not considered to be listed in the annex. They also set out the constituents of articles that were manufactured or already in use before the entry into force of the obligation with respect to that chemical are also excluded. But there is a condition that those articles in use do need to be notified and remain within that party. There is also a possibility to notify closed system site limited intermediates, which are available for a 10-year period, unless the party submits a new notification, and that can be extended, except if there's a COP decision otherwise. So the intention being where there is less risk of the chemical coming into contact with human health and the environment and having an adverse effect. The intention of the overall intention and objective of the convention always being at the forefront of our minds and looking at protecting human health and the environment from these POPs. There is also a requirement for registration, and there is a particular exception to that, which is for PCB in articles in use, which may be exercised by all parties without the need for registration. And again, the provisions for that are set out in a specific part to the Annex A. So in terms of what is available, and I guess this is a question that is at the forefront of many stakeholders' minds at the present time. If you looked at the publication of the convention text, you would see, as we mentioned before, this initial part, which includes the list of the chemicals, the production and use, and whether there's a specific exemption available. This is reflecting the decision that was taken by the COP to amend the Annex A, B, and or C to include that chemical, and reflects what is available or not. We do compile all of the depository notification texts and put them into this publication for the sake of making it easier to have all of the information about the POPs listed under the convention and which exemptions are available. When there are no longer any parties registered for a particular type of specific exemption, no new registration may be made with respect to that, and that's in accordance with the Article 4. And to make it easier, all of those are indicated in grey. So we gave a couple of visual examples on the screen at the moment. If you were looking at chlordane, for example, you see that all of the entries on the right-hand side are indicated in grey to say that no new registrations may be made with respect to those. There is an explanatory secretariat note, note 2 to annexes A and B, setting out why it's presented in that manner. And maybe to highlight in particular the listing that relates to UV328, simply because for that one, there are two different amendments related to the listing of that chemical. with two different dates of entry into force. So the first amendment related to listing of UV328 has already entered into force for most parties. That entered into force on the 26th of February 2025. There is the further amendment that will enter into force for most parties on the 9th of October 2026. Bearing in mind, of course, that you do have the possibility for parties to opt out, to send a notification of non-acceptance of an amendment, as well as those parties that, when they became a party, indicated that the amendments to Annexes A, B, and C would only enter into force for them when they explicitly consented to be bound. So we refer to them commonly as the opt-in parties. So those may have some slightly different dates of entry into force. In terms of what is available, so there are a number of specific exemptions where there can be no new registrations made. So the initial POPs that were listed when the convention entered into force and had exemptions available for them, those have since expired. There are also certain applications for decabromodiphenyl ether, as well as hexabromocyclododecane, lindane, pentachlorophenol, SCCPs, PCNs, and technical endosulfan. So for those exemptions, the COP has indicated in various decisions that no new registrations may be made in relation to those exemptions. The most recent being in decision SC 12.1, where there was an indication in relation to DECA-BDE and for PCNs. For DDT, you will see that some of the entries are in black from the convention text to indicate that the acceptable purposes are still available. However, the specific exemptions, which were time limited, have already been indicated by the COP that there can be no new registrations of those specific exemptions. There is, for certain chemicals, a review process that is periodically undertaken. So this would be for hexa and hepta, tetra and penta-BDE, for PFOS, for PFOI, PFOB, in relation to the listing to include PFOA in Annex A. Medium chain chlorinated paraffins also has a review process, as do UV328 and Declaran Plus. There is a periodic review by the COP that is based on information that's gathered by the Secretariat and reports that are prepared by the Secretariat and by the POPs Review Committee. That may end up in consideration of the reports and then a decision by the COP that there is no longer a need for those specific exemptions. The most evident example being PFOS, it's salts and PFOS-F, which were initially included in Annex B with specific exemptions in 2009, and then there was a subsequent amendment in 2019 when certain specific exemptions were deemed that there was no longer a need for those. So how to register? What are the processes that apply? In terms of the timeframe, the convention sets out that on becoming a party, you have to notify in writing to register for one or more of the specific exemptions. Parties register on the date of entry into force of the amendment for them. So looking ahead, we have the amendment listing chlorpyrifos, which would enter into force for many parties on the 16th of December 2026. But parties can register at this point in time. If we receive anything in advance, we do publish that on the date of entry into force. This is not to say that the Secretariat would refuse registration that's received afterwards. We do continue to accept the registrations. There's nothing in the convention that says that it has to be at that particular date, but we do understand that it is on becoming a party that the provisions enter into force or kick in. There is a COP adopted format that is available on the website. And the registration expires, as we mentioned when we were talking about Article 4, 5 years from the date of entry into force, and when there are no longer any parties registered for a particular type of specific exemption. Just thinking about the registration as well, and bringing to your attention that there was a provision in Decision 12.1 that urged parties to identify on becoming a party the need for these specific exemptions and to register them in accordance with Article 4. And it also reminded parties wishing to register to do so using the relevant forms. Looking maybe one step before you get to the forms, there usually is a national process beforehand to identify whether there is a use or production of the chemical at the national level, to see if there are alternatives looking at, for example, technical feasibility, costs, efficacy, risk, availability, and accessibility, and how much time may be required to phase out these chemicals. It's up to each party to determine if it wishes to or needs to register a specific exemption, and if a shorter duration is sufficient. So it is possible to indicate, and that has been done by some parties in the past, that you need 1 year, 2 years to maybe put in place measures to ensure that you have sufficient control of the new POP that is listed. So that could be indicated in the form. Of course, any extension of the 5-year period would require a decision by the Conference of the Parties, which we'll look at in a minute. But all of the forms have been adopted by the COP and are available on the convention website. You have the link there. There is a specific form for the chemicals listed in Annex A. When it comes to Annex B, you just have exemptions available for the use of PFOS salts and PFOS-F. So there's a form for that as well. And then you have forms in relation to acceptable purposes, articles in use, and closed system site limited intermediates. The form requests specific information, to identify the chemical, to indicate the duration of how long the exemption is being requested for, which activity, so whether it's for production and or use, and the specific exemption as set out in the relevant COP decision. There is also a request for estimated quantities of annual production and or use, a space for the reason for the specific exemption, as well as additional remarks. We would ask that the form is transmitted to the Secretariat through the official contact point of the party, of each party. And these fields should reflect what is in the convention text, in particular when it comes to the chemical name and the specific exemption. Those are some areas where we've noticed that there are a lot of questions that are arising. So we would certainly highly recommend to have on the one side the convention text open, and the other side the form, so that you can ensure that that matches. There is a process that was adopted by the COP as well for requesting to extend a registration of a specific exemption. To date, that's only been used on one occasion. It was requested by the Republic of Korea in relation to the amendment listing PFOS, and there was an extension granted by decision SC 12.1. In terms of the process, the whole thing would begin at least 12 months, or rather before the 12 months of the last meeting that takes place before the expiry date of the exemption. So if you had, for example, going back to what we were looking at earlier with chlorpyrifos, and an amendment that enters into force in 2026, in December 2026, that would mean the expiry date would be 2031 December, and the COP that takes place at least 12 months before that December 2031 date would need to receive that request from the party. The request is sent to the Secretariat with a report justifying what is the continued need for this exemption. That information is circulated to parties and observers by the Secretariat with a request for further information in accordance with the process. And that needs to be provided within the set time frame so that it can be presented as a document before the COP meeting. The COP then subsequently decides on whether to grant that request or not for an extension before the expiry date of the exemption. So the timing of these is absolutely crucial to ensure that that decision is taken at the appropriate time set out in the review process and well before the expiry date of the exemption. How does the availability of exemptions affect trade in these chemicals? Well, parties have an obligation to prohibit and take necessary measures to eliminate production and use of chemicals in Annex A and import and export of those chemicals. There is also an obligation to restrict production and use of Annex B chemicals. So there need to be these measures put into place. In addition, when you're looking at whether you can import or export the chemicals, you would need to be sure that that is only in the case of import, it would only be for environmentally sound disposal of that chemical or for a use or purpose permitted under Annex A or B. And for export, it would only be possible for environmentally sound disposal to a party that's permitted to use the chemical under Annex A or B, or to a non-party state which has provided an annual certification. To highlight there that when we refer to a non-party state, that also includes a party that has not agreed to be bound by a particular chemical, so the opt-in or opt-out parties. So it's a question of taking the decision at the time of entry into force of whether you would need an exemption. Is there an exemption available? Going through the necessary steps at the national level, as well as the notification registration at Secretariat level. And then also making sure that these conditions for international trade are met, so that you're in accordance with the conditions for international trade under the Stockholm Convention. So with that, we come to the end of the Secretariat's presentation segment of the webinar.